This is an overview of the United States Court of Appeals for the Ninth Circuit case Perfect 10 v. Amazon.com. Perfect 10 was an adult entertainment company that ran a subscription website. Subscribers had access to members-only images of nude models as well as access to reduced-size images that they could download for use on cell phones. Third-party websites published Perfect 10's copyrighted images without their authorization. Google's search engine automatically crawled the web and indexed these third-party sites. Thumbnail versions of the infringing images hosted on those sites would appear in Google image search results. If a user clicked on the thumbnail, a frame would appear in the browser and display the full-size image in its original context. Perfect 10 sent notifications to Google that it was displaying and linking to infringing material for over 4 years. Amazon had an agreement with Google and displayed Google search results within its own user interface using inline linking to the same thumbnail images that would appear in a Google search. Perfect 10 filed an action against both Google and Amazon, which the district court consolidated. The court granted preliminary injunction partially against Google but denied injunction against Amazon. Both Perfect 10 and Google cross-appealed. The question that was discussed in this case is, does displaying thumbnails of and hyperlinking to infringing images within web and image search results constitute fair use? Perfect 10 claimed Google's inline linking, framing, and displaying of thumbnails was a direct violation of its display and distribution rights. Using the server test, the district court reasoned that if a person stores an infringing image on their computer and then serves it via the intranet directly to another user, then he or she is in violation of the image owner's copyright. But because Google does not host the infringing images and merely links to the full-size images hosted by the other third-party sites, Google is not in violation of Perfect 10's display rights. The Ninth Circuit agreed, noting that as far as inline linking and framing is concerned, Google is only providing the HTML address of where infringing images exist online. This is not the same as displaying a copy of an image. Likewise, because Google does not own a collection of Perfect 10's images and does not communicate them via the use of its search engine, Google's index of images is not a violation of Perfect 10's distribution rights either. It is the third-party website that distributes the infringing copies, not Google. Google's display of thumbnails, however, is a different matter. The thumbnails are stored on Google's servers. Using the same server test logic, this is a violation of Perfect 10's copyright. However, Google argued that its use of thumbnails constitutes fair use. While the district court ruled in favor of Perfect 10 when evaluating the fair use factors, the Ninth Circuit overturned their decision. They determined Google's thumbnails were highly transformative, citing the case Kelly v. Ariba. The purpose of the images were transformed from entertainment to informational and very beneficial to the public. Perfect 10 argued that Google's thumbnails negatively impacted their sale of reduced-size images, and also that Google financially benefited by linking to these infringing sites through its AdSense program. But there was no evidence of this occurring. The appellate court concluded that the highly transformative nature of the thumbnails outweighed any commercial use or potential market harm to Perfect 10 and thus is fair use. Perfect 10 also claimed Google is secondarily liable under contributory and vicarious infringement, citing MGM v. Grokster, quote, "One infringes contributorily by intentionally inducing or encouraging direct infringement, and infringes vicariously by profiting from direct infringement while declining to exercise a right to stop or limit it. A service provider's knowing failure to prevent infringing actions could be the basis for imposing contributory liability. The court could not deny that Google substantially assists websites in distributing their infringing copies of copyrighted works, even though this assistance is also available to non-infringing sites. So, applying the Grokster test, the court concluded that Google could be held liable if it had knowledge that infringing images were available and failed to prevent damage to Perfect 10. Looking at the vicarious infringement claims, because Google lacks image recognition technology, Google has no ability or right to stop or limit the infringing conduct of the websites it links to. Even participation in its AdSense program does not give Google the ability to shut down a website. So the court agreed with the district court's holding that Perfect 10 has not established vicarious liability. But wait, what about the claims about Amazon? Amazon inline linked to Google's thumbnails, so based on the server test, this cannot be considered a direct infringement either. Perfect 10 also claimed Amazon was vicariously liable for the infringements of third-party websites, but the site has even less ability to police or supervise infringing activity than Google does, and they lack a financial interest in such activities. So, there are a few matters that were left open for the district court to reinvestigate. First, were Perfect 10's infringement notices compliant with Section 512, and were they sufficient enough to inform Google and Amazon to take action against infringing websites? Secondly, are Amazon and Google contributorily liable for having actual knowledge or infringing activity and failing to prevent it? And finally, are Amazon and Google shielded from liability under the DMCA? The Ninth Circuit did not reach a decision on these questions and remanded to the district court for further proceedings. In conclusion, there are three big takeaways from this case. First, storing an image on your computer and sending it over the internet directly to a user violates the display rights of an image's copyright holder. But using inline linking or frames to display a full-size image does not infringe those rights. And finally, appropriating a copyrighted image as an index thumbnail picture for use in search engine results is a protected fair use under the copyright law.